case briefs, and so much more. LSData's got what you're looking for.
In the 1983 Vallone v. Miller case, heard by the Texas Courts of Appeals, the law's stance on jointly owned property being sold by one spouse without the other's consent or written agreement was brought into question. The dispute centered around a real property contract between the appellant and a couple, James B. Miller and Elaine R. Miller. The earnest money contract stated that Mr. Miller would sell the property to the appellant, with both Mr. and Mrs. Miller named as sellers. However, only Mr. Miller signed the contract. The appellant argued that Mrs. Miller was bound by her husband's signature as he had the right to manage the property. The court, however, found that joint management community property could not be disposed of by one spouse alone unless there is a written agreement to the contrary, and denied the appellant's request for specific performance or damages. Upon appeal, the court upheld the initial decision, stating that the contract was not valid or complete due to only bearing the husband's signature, and Mr. Miller lacked the authority to dispose of the joint property without his wife's involvement. The trial court's judgment was upheld, and the appeal was denied.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.